Oh, sorry. Because you mentioned serial number 46 and 46-1. This matter was specifically fixed today at 2 p.m. for final hearing. This is arising out of a foreign award which has been ordered to be enforced by the Madras High Court. Obviously, your lordships are busy this afternoon.
Please wait for the turn. This is not the way we just wait. We will take up your matter. It's not that we will not take up.
Very well.
May I please? Sorry, sir.
Item 56.
Yes, my lords, may I address your lordship?
Can I come back? Just please. Sir.
When is Skora, we were there right now. All of them were there in the.
I have the no, sir. I think I have the pleasure of representing them.
Tell them to bring here also.
Yes, my lords. They had Justice Bindal's farewell was there.
Representation.
No reservation.
There's a saying in Bengali.
Yes, my lord.
That the darkest place is below the lamp.
Yes. Correct.
Don't make it the darkest place.
No, Dr. Menaka and I are not here, my lords, to oppose.
No, my lords, we accept your lordship's decision entirely. And support. We want to make it possible.
The best part of the Supreme Court members of the bar, we are broadly using the word.
Yes.
Is that SCBA also very graciously themselves.
Skora also.
I think
Absolutely, my lords.
We have just come here.
We welcome it,
We leave
my
it to your lordship.
We welcome your lordship's decision on this.
May I also be permitted minutes? May I also be permitted minutes to assist minutes on 1 point minutes? If
and but she
with permission minutes, just one small issue minutes. If
there is no need, you can tell Dr. Menka, tell Gaurav whatever you want to say.
I am for an interview. Minutes, I am an advocate on record here. Minutes, I have been a former member. Minutes, just two aspects minutes may consider when one is minutes whether this petition, as it is filed, it is asking for representation on the basis of exclusion minutes.
We know that you are opposing in the name of suggestion.
I am not minutes. Not at all, minutes. Not at all. In fact, I welcome minutes the step the SCB and the bar councils have taken minutes. These are the important issues minutes because advocates on record are a separate class minutes because the.
All right, thank you very much. Thank you. Now tell us which are the OP. The one is president, then you have vice
Page
president.
38, lordship. Page
38.
38 have all the posts, lordship may whichever two posts and 1/3 of the executive members. Lordship have page 38.
Why don't people of you just discuss? Dr.
Yes.
Menka.
Yes, my lords.
Yes,
you and Gaurav, all of you just
Yes.
Yes. Yes,
We'll do that. We'll do that.
So two posts and two members from the executive minutes. So whatever lordship has decided, minutes. Whatever your lordship said, we are all on the same page. Minutes.
We welcome it.
Yes.
We want to see some change, so we
Absolutely.
welcome it.
Whatever your lordship think fit is proper. Minutes.
Yes, always, my lords.
Yeah, what should we do? We have secretary.
Secretary, yes.
Yes.
So we can go for secretary.
Secretary,
Very
yes.
well, my lords.
And we have very, I think all of us have very pleasant experience of
Pragya.
Pragya. She has done a very commendable job.
Amazing, yes. Amazing, yes. So secretary can be one, it can be treasurer or joint treasurer, whatever your lordship.
As your lordship sees fit, my lords.
Dr. Menka, you were saying something?
No, my lords, as your lordship sees fit. Secretary, treasurer, maybe both positions.
SCB is started with treasurer. SCB is started with treasurer.
One or only two?
Two will be better. It may be that they will normally get elected also, but
Hence, and joint treasurer can.
right.
Very well,
Very well.
very well.
Very well. And two posts in the executive members.
And two executive.
Yes, ma'am.
Say the issue pertains to ensuring adequate representation to women in the composition of executive committee of office leaders of executive committee of the Supreme Court advocates on record. Both sides have graciously and fairly, on our suggestion, I agree that in the ensuing election of SCORA, the post of secretary and joint treasurer and 2 executive members may be earmarked for representation of the women advocates on record.
Millets.
They say, invoking our powers under Article 142 of the Constitution, be ordered a court.
Millets.
Now we are happy.
The time they
We are
will,
happy now.
Minutes,
sir,
the larger issues were involved minutes because then minutes may also would have considered at the level of entry also minutes. The question of, these are the larger issues in context of only AOR's minutes I was submitting.
All right.
As
I'm
minutes-
saying whether there's a
as
requirement to
minutes-
extend the time or SCORA will be able to do it in this time
The
frame.
schedule remains the same.
They'll do.
Remains the same. There's no problem, my lord.
All right.
Yes,
Yes.
absolutely.
Nomination is anyway
Grateful.
starting from 15th April
So,
until
Yes,
20th.
no difficulty. I just wanted to inquire. Grateful to your lordship.
No problem. We're also very grateful, my lords.
thank you very much.
If you have-
Obliged.
Lords, 57, my lords, I'm only aggrieved with the non-grant of stay insofar as the proceedings are concerned, and I'll tell you lordships why.
Item 57.
57, my lords, this non-grant of stay, my lords, is my only worry, and I'll tell you lordships why.
We shouldn't entertain this kind of.
No, I'll tell you lordships why, my lords. Lordship may kindly see, after the FIR gets filed, there is a closure report that comes to be filed by the CBI. While, my lord, setting aside the closure report and order further investigation, Lordship may kindly see what the order passed by at page 206. Lordship may kindly see. 206 says, my lords, that insofar as this entire final report is concerned, it does not say and it does not adhere to the order passed by the High Court while transferring the matter to CBI, which says, please find out the gamut of the so-called scam insofar as the number of people who could be victims. CBI makes a specific, my lords, moment saying that we could not find any single victim insofar as this company or the scam is concerned. My lords, the chief,
The state of Mizoram is the biggest victim.
my lords, and that,
The state of Mizoram is the biggest
my
victim.
lords, and my lords, that is the,
Your public
Don't take
servant
light of
is
this.
swindle away the name of the state to permit a criminal to perpetuate multi-level
my
murder.
lords, but that is what the CBI says has not happened. When it filed
You
the
want us to write all these things in the order.
no, my lords, I am only requesting, my lord, lordship.
Frivolous petition dismissed. The moment we will write 2 lines, it will become problem for you.
Lordship,
Yes,
I have
please
compiled a
consider-
brief note for your lordship's perusal. Madam, I would request you to please pass it on.
See, Mr. Diwan, probably you were not there last time. There was just only very preliminary observation we will say. Not prima facie, only preliminary observation. Now this IRP is under cloud. Whatever may be good reason.
I have nothing to say on that, but I have something to say on the other aspects. Because we received a copy of the only on Saturday. And this Saturday, after the order came to be passed, we were not aware of the application being made, etc. So I am just, I don't want to get into it. First of all, I have indicated to, as far as my client is concerned, I am not saying anything at all as far as the IRP on that. But on the rest of it, we have something to say, which is why we filed an application for, which we've served on the amicus, for recall, so that your lordships can then adjust the equities, etc. appropriately. So I'm suggesting, I mean, we can do it today, but if they want some time, then on with regards.
Response is ready, you can give, we can keep it.
Yes, yes, I have a submission. This is my recall.
Then we may examine this
Yes.
response also.
To the chief, I.
Can I take 1 minute, my lord? My lord, we are appearing for one of the banks, IFC. I'll just take 2 minutes. My lord, your lordship's earlier order classified the entities into 2 broad buckets. NBCC, unfinished projects as one bucket, unfinished projects as another bucket. We are a case where, my lord, our project is completely finished. It is operational. It is functional even today. And there is a default. We don't have any problems of construction or a home buyer, nothing. It's all working. Only problem is default. So, my lord, this is not as originally conceived, a separate CRP, CIRP, or C, whoever can be occupied to do it. I'm the only financial creditor. I hold 85% stake in the COC. So what has happened? Earlier order, your lordship directed us to go to NCLAT, which we have done. Our IA is coming on Friday. But day before yesterday's order, my lord, please see one paragraph your lordship may see. Paragraph 4 and paragraph 5, which, my lord, if we can show only one suggestion, very respectful in consideration. If your lordship sees paragraph 4, do it please. Although, as this is pointed out by so-and-so learned senior counsel, the IRP has challenged the suspension order before the Delhi High Court. It seems to us that the projects, meanwhile, must be completed under the court-monitored action. Proprietary demands that the IRP, till he is fully exonerated by the court or any other prescribed authority, should distance himself from the ongoing proceeding. I am appearing for the IBBI in the Delhi High Court against this IRP.
At your instance,
And we have filed an appeal before the Delhi High. They filed a we have responded. We therefore find merit in the recommendations made by the learned amicus that a court-monitored mechanism be adopted to ensure the completion of projects by NBCC takes place without any hindrance. Paragraph 5. At this junction, we hasten to note that there are approximately 30 projects undertaken by the company in question, out of which 16 have been entrusted to NBCC for completion by way of judgment dated 12/12/2024 and order dated 5/2/2026. In our considered opinion, the issues relating to the remaining projects also ought to be administered within the same court-monitored framework. Accordingly, the underlying policy with respect to all projects, whether fully completed, substantially or partially completed, or which are lying incomplete and inactive, including those which have been handed over to NBCC, shall be determined by a common authority that may be set up by this court. But 5 of them form one cluster. There is no difficulty at all. Substantially, partially, incomplete, or inactive, they are all form. Our projects are totally completed and it is operational, it's functioning, and yet default is happening. So we are moved an IA before, as per your lordship's previous direction, earlier direction, we have all been asked to go to the NCLAT to fight our rights. We have filed our IA. It's coming up on Friday. So can completed projects alone be taken out of this list? Rest of them, my lord, they form a one class. There is no difficulty.
No, we have something else to say, because if it was original appeal was confined to 16, our respectful submission is that it ought not to be expanded to 30. I don't know what he might, I'm not for a moment opposing what is being suggested just now. But suddenly from the scope, because the balance 14 projects are pending before NCLAT. They are pending, they were not the subject matter of the original appeal.
This was only during the course of very brief hearing.
Yes, brief hearing.
This was our idea, because if 16 projects under a court-monitored committee continues and those projects are completed, or the home buyers in those projects are to their satisfaction able to achieve their and the other projects are maybe in, that's why we use the word partially incomplete or substantially.
Correct. But please hear us on this, because it was not the scope. Your lordships disposed of the appeal. Now everybody is before NCLAT.
I am appearing from the home buyers. Appearing from the home buyers. 2011.
I take serious objection. The MA ought to have been served on every party. That's the least which the amicus curiae must do. The second is that at least he must serve us a copy of the report. Without having a copy of the application, no notice served on an MA, a report filed, served on me after the order is passed. Your lordships have used the expression, in fact, over here, which speaks about propriety. I would respectfully submit that propriety at a minimum requires that in a disposed of case, when a miscellaneous application is filed, at least it must be served on the parties along with supporting documents. That's the least.
No, supporting documents is, it's not, everything is admitted on record that IRP has been found guilty of something.
No, it's not, my lords, I'm sorry.
Based on the suspension. Now the committee which has been looking after the Apex committee is headless. All these are a matter of record.
I have no problem with that. I started by saying that, look, if there is some practical difficulty, in fact, what ought to have happened in a situation is go to NCLAT and get it substituted by NCLAT. How do you, in a disposed of appeal, come over here, file a report, don't serve it, and secure an order like this, which is a tremendous variation?
No, you see, amicus has no interest in the matter. There is no question of any securing order by him. This order is only because he pointed out this suspension part to our information.
So that may be retained, my lords. Para 4 may be
By
retained.
virtue of the approval we granted to that order. Therefore, because by virtue of an order passed by us, if a person whose conduct unfortunately for any reason is under cloud, that's why we said that there has to be a court monitor
So,
committee.
my lords, on that I started by saying I have no problem, but please confine it to para 4.
But may.
Consider it.
Yes,
Yes,
May-
also
may-
projects,
may-
that's the problem.
There is
I
a submission mirrored for the home buyer. The submission is this: we are equally placed other than 16 project mirrors, and these projects are also 2010-11. They are incomplete, and your lordship but rightly said,
That part.
yes, mirror. Grateful.
Very was that in 16 projects which we are giving to suppose the court monitoring committee, those projects will be completed. Part of the home buyers will be happy. Rest will be again making.
Exactly, mirror.
But on that, there's no
Propose
problem,
that
my
we
lords.
support it, mirror.
That there's no problem. 16 was what the scope of the original appeal is. If someone wants to increase, your lordship appointed the amicus to assist the NCLAT proceedings. Now over there, we will have our day in court and we will assist over there. So any variation to be done because of exigencies, etc., can certainly be done before NCLAT. But suddenly to come over here, expand the scope beyond the original appeal.
NCLAT is not going to regulate our proceedings.
Correct.
No, of
Correct.
course not. But your lordship disposed of the appeal.
That is the court initiative only to bring
Other than
parity among all the home buyers
correct.
and to ensure that some of them do not feel that they have been left behind.
No, those are
And are equally placed.
These are delivered projects, the other remaining projects.
Complete projects where everything is complete.
Yes.
No, they are not. They are not completed projects.
Yes, my case, don't mix up.
But
Not
I-
in my
I have
case,
one
I
thing.
say, I can say it on an affidavit, complete project.
We find a merit even in complete projects. Suppose the financial institutions are yet to recover.
Yes.
No, so that can be worked out before NCLAT because that issue, which your lordship is correctly placing before me, is actually pending before NCLAT. NCLAT itself had 17 on one side, out of which one is completely complete. So that was not part of the 16 which your lordships held. And then you had the balance projects. That issue is under consideration of NCLAT.
That said, that may not be a ground for us to just ignore the ground reality that's going to happen.
There is no
If
There's
suppose
no
that
ground reality, my lords.
IRP was there, then this issue was not there. Because IRP was there and it was IRP for the entire company, for the entire entity he was there.
No problem, my lords. You can, as I said,
For the
if there's a
16th
substitute IRP, we have no problem with
No
that.
problem.
Lord,
We have no problem with that.
May I just bring one fact to my lord's notice? Just 1 minute. My lord, a financial creditor in relation to the 16 projects, my lord, where the apex court committee was constituted and where your lordships, my lord, have noted that IRP is now suspended. My lord, we appear for the financial creditors. The composition, my lord, that was determined by NCLAT, which your lordships found favor with was total 5-member committee, IRP who now goes out. My lord, 2 members of the creditors, 2 largest creditors. One was NBCC, 4th was an independent person. My lord, all the other persons are still there. My lord, this committee has done considerable work. Instead of having, my lord, a completely new committee, if the IRP goes out, any judge or any person your lordships thinks appropriate can replace the IRP.
We will appoint an independent committee with some or the other, the ACC, there is an apparent conflict of interest also.
Apex committee.
These are there. We have
But
to-
then I have only one request. If your lordships are inclined to appoint a completely fresh committee, my lord, my only request is, like your lordships were pleased on the last occasion to give representation to the creditors. Your lordships gave us 2 seats, my lord, out of 5. But I'm requesting, my lord, that your lordships may, my lord, appoint any new committee will be with your lordships completely. I'm only praying, my lord, let the financial creditors continue to have that representation.
And the home buyers also.
I have no difficulty.
You see, financial creditor, in any case, their interests will have to be protected, and I think earlier orders are there adequate enough. We can,
My lord, only thing that
in
happened.
all directions, we can.
If only thing that happened, my lord, in the committee, my lord, as proposed by the learned amicus, which is, my lord, following what happened in the subsidiary matter. My lord, none of the creditor representatives are inside the committee. So what happened is all our suggestions and inputs are now externalized. If you are a part of the committee, my lord, when the committee itself is considering, there will be an internalized input that would come.
Of our experience of appointing independent committees in some of this kind of projects has fortunately been quite satisfying. We will not say that it has been very really outstanding achievements, but wherever in certain other projects, such committees have been constituted, at least home buyers' interest has been adequately.
Correct, correct.
financial institutions' interest has also been to some extent protected. And there is at least no sense of insecurity created as far as their interest is concerned. So we are quite.
My lords are right, but if you may just bring to my lord's notice, just a minute,
May I,
if you may bring to my lord's kind notice, what happened is, my lords are completely right, my lord, I respectfully bow down. But in some of the committees, my lord, what happened is where the creditors' inputs were not considered at all, there are litigations now coming before this honorable court. All that I am requesting is, lordships may have home buyers representatives, if, my lord, that is a request that is being made and if it appeals to my lords. My lord, your lordships may only provide, unlike the Supertech realtors, my lord, where none of the creditors' representatives were on that particular board, lordships may kindly have representation from the, my lord, creditor side also, like your lordships were pleased to do in this very matter on the last occasion.
That part, once we constitute the committee, will pass an order in open court only.
Because, my lord, para
I think
6,
that Mr. Diwan has filed some objection, Mr. Jain, you may consider those one also.
in para 6, just a minute. My lord, in para 6, your lordships were pleased to.
we filed a recalling.
In the submissions, because we have traveled substantial
Certainly good.
distance. Most of us we have taken.
The word substantial creates problem.
No,
If you say,
We are saying full. I'm saying full. It is operational. It's working and they are defaulting.
if you say the.
In spite of working, they are defaulting.
We will happy a statement if you say project complete, home buyers possession delivered, financial institutions paid, transferred, sale deeds have been executed, conveyance deeds are.
Sale deed registration, sale deed.
Yes, we are very happy.
Not in my case, no home buyers are involved. It's a Malcolm hotel, completely functional, and they are defaulting. Therefore, my lord, can I move an IA? Might be permitted to move.
Because the details of all those projects.
Yes,
are very.
we'll give it up.
Like to.
Maybe.
Yes,
Have to examine.
Lordship, in your order dated 5th February, your Lordship, para 20 states that the amicus may approach this bench in case there is any impediment to the implementation of your Honorable Court's order. Consequently, once the IBBI passed the order against the IRP, there was an evident impediment in the implementation of this bench's order. Hence, I move that petition. At the same time, your lordship, you need to factor in this, that Supertech is a legal entity registered under the Companies Act. It's a corporate debtor. It not only has projects, it has other things. It has investments, for instance. It has subsidiaries, over 24 subsidiaries. It has litigations. It has relational party loans and transactions. All those would need to be taken care of by an entity. Currently, what do we have? Currently, in the absence of IRP, we have nothing. If we agree to the proposition that it is only, ACC is only for the 16 projects, then who looks after the rest of the company? What happens to the surplus of non-16, or say a receivable from a subsidiary? Who manages the boards of the subsidiaries? There are issues which the company as an entity has to handle. There has to be a credible body like the board of directors discharging the functions of the board of directors. If not ACC, then who? So in the current dispensation, there was no COC, sir. And if ACC is only looking after 16 projects, then who's looking after non-16 and rest of the company? Only the IRP. I'm sure that was not the conception of the honorable bench. So the company has to be looked after. The company's interests go far beyond 16 projects. And home buyers we need to put in a structure in place that protects the interests of the home buyers, and then the lenders and the authorities.
Anyway, we'll put in our objections in 3 days' time, and your lordship may list it next week or whatever.
Yes, also you can give your.
Yes, my lord, we will also.
But even on the composition, my lord, we'll place our submission.
Take it on next Monday then.
Yes, very well, very well.
But even on composition, my lord, we'll place our submission. Your lordships invited it at para 6.
Your lordships,
may I make one request?
Can it be next Friday, my lord?
Lordships notice just that I may failing in my duty to inform that there has been an amendment in the code, my lord, on 5th of April 2026. And the new guidelines have come on 7th of April 2026, which the amicus is not aware of it, and probably it did not be informed to the court also, my lord. Lordship may appoint the IRB, but that amendments have to be taken into consideration because it has now come as a project-wise, my lord, not independent, not as a composite, my lord. And somebody in grieved out have to go independently to the NCLAT, my lord, not like in a cluster, my lord.
Lordship, project-wise committees have not been formed so far.
This is the amendment, my
In
lord.
the NCLAT's order of December 24, the project-wise committees also had a role in finances because the NCLAT stated that the ACC has to conform to RERA regulation of apportioning the funds into 70-30 ratio, wherein 30 would meet the dues of the lenders and the authorities. However, this honorable bench ordered that first, the project has to be completed, home buyers' interests have to be met, and only subsequently the surplus has to be diverted to pay the dues of such and such. Now, so the project level committee no longer have a financial role. And the project level committees have not been
To
constituted.
have a separate committee for each project because.
At the same time, sir, since projects are spread in different places and the lenders are different, the home buyers are different, in some cases the authorities are also different. And the Apex committee may not be physically capable of supervising the implementation of the NBCC project at all the places or monitoring the grievances of all those projects. Consequently, some kind of a structure which maybe the ACC can think of or someone else, that some kind of thing needs to be there at the project level to handle the project related issue, except for the financial part.
ACC is the Apex Code
Lord,
Committee.
may I
Can it be on 24th, Millard?
May I bring the notice to amendments?
Stock suggestions, if any, to the proposal, to the recommendations made by the London Micros,
Amendments.
which are duly incorporated in our order dated 10th April 2026, may be made within 3 days. Post this matter for further consideration.
Can it be on 24th?
Submission.
24th or 27, Millard? Home buyers have to file also.
Next Monday, because the urgency is there.
Millard.
Yes, yes.
There is, nobody is working and we have stopped, there is an interim order.
Yes, and Manoj, may I, that I have handed in an MA that may be registered, Manoj. So I'll put in my replies also separately.
But I have passed on the amendment also, my lord.
And I may be given a copy of the MA.
Section 526. Next please, 526.
Yes, yes, please pass.
What do I know?
I have passed on the amendment, my lord, for your lordship.
State will consider them together. You give to the amicus.
Yes, we. Amicus.
Manoj, would that MA be numbered? Which we have I've taken out an MA with e-filed, etc.
You ask your junior to file now in the registry because.
Yeah, no, we'll file in the registry. They say that because it's a disposed of appeal, they don't number it.
Permission would be required.
Without your permission.
Permission would be required, my lord.
The registry directed to assign the number. Post this, I may on the date.
Grateful.
So great. Suspension may be allowed.
Malaj, I beg to appear for the state, Malaj. The file and record is here. We filed a status report. It may not be on record, Malaj. I'm carrying copies. Malaj, broadly, if your lordships will see, Malaj, the charge sheet is actually filed under the enhanced sections, Malaj, of POCSO. In fact, the enhancement happened on the very next day, Malaj, after the inquest report and postmortem. So we are carrying, Malaj, your lordships had permitted the commissioner to go back, but the Malaj ACP, the SHO are here. Original files, because the charge sheet has been filed and cognizance is also taken, Malaj. They are with the
That is what is happening, and sometimes it's quite disturbing that suddenly somebody wants to come to the court. Then you say the charge sheet has been filed.
In this case, the charge sheet was actually filed even before they came. So the date of the charge sheet here is, Malaj, 3rd of April 2026. So on the writ petition does not disclose it, Malaj, but the charge sheet was filed on 3rd of April 2026 and cognizance was also taken.
My lord, I have certain things to say. If you see what the status report which has been filed, on the last date of hearing, I had submitted specifically that there seems to be an attempt to shield the hospitals concerned. One, they have not served the hospitals despite your lordship's directions. They are yet to come on record. Secondly, you will find that the policemen have gone around, recorded statements of people saying this, that the child was found not breathing at that point of time. The video is speaking otherwise. Why don't they inquire into that? An SIT needs to be constituted because there seems to be a concerted effort to see to it that this is completely taken away from the record. Even now, despite the fact that there were directions from this court, and even the postmortem does not direct an inquiry towards the aspect of sexual assault. This is the manner in which these investigations have gone on. One can really...
Charge sheet has been filed under which provision?
Please, my lord.
Have you mentioned any charge sheet?
The charge sheet I have yet to see. They are yet to file that record. I'll have to look into that. But the status report which they have served on us.
So the Status report, your,
Hospital is concerned. Whereas we have been served on Saturday
we've
night.
served the hospitals also.
Was served on Saturday.
Lordships will see para 18 of the status report, my lords. The charge sheet has been filed
Respondent 4, my lords.
under section 66, which corresponds to, my lords, section 376A, 5 and 6 of POCSO Act, which is aggravated. Lordships will have para 18, my lords.
And murder and
No, no, my lord, here the issue is that when the child was alive, do private hospitals have the discretion to say that we will not treat you, we will not admit you,
then that is not a,
and the child dies thereafter?
that is not a part of prosecution.
No, that is also a part of it.
That's not a part of prosecution.
But what I am trying to say is, my lord,
Your main thrust will be against the offender who has.
no, that as well. As far as the offender is concerned, when the FIR came into place,
In the nature of, I think 357B. of
no, my
the
lord.
old code.
Here, in fact, offences independently are attracted against the hospital in relation to 304. Because at the time when the child was brought there, if that aid was given at that point of time, the child would have survived. You, in fact, hasten the death of the child by not admitting the child and giving the child the treatment at that point of time, especially when there are directions from this honorable court that nobody can refuse. That is what is also bothering me. We have lost a life, and especially our 4-year-old child, because that medical intervention didn't happen.
We have,
Not one hospital, 2 hospitals, one after the other.
we have penal provisions.
Apart from that, there are penal provisions in relation to that.
We have penal provisions for the failure to record a report. Record a report at the police station in respect of a sexual crime.
Even that was not done. If your lordship sees,
Now, hospitals will not record it, right?
no, I am not saying that.
Just examine according, in light of your submission, which is quite distressing that the hospitals did not extend medical relief, and that would be a breach of Article 21 rights in the form of a constitution tort. Whether that would.
No, it would not be a tort alone, my lord.
That is what we should expect.
In a normal case where it's a
Whether-
situation,
Whether this would transcend to crime.
yes, it would.
What would be the offense according to you? 304.
I would say 302 at the highest, but 304 at a lesser degree. Because you are fully aware of the fact that there could be a situation where the child may not survive. You have that knowledge. And the police shuts its eye in relation to that, records statements contrary to the situation in the. I will only urge one thing, my lord. Your lordship may kindly see
The prosecution should be against the principal accused.
the principal accused also, my lord, initially was to shield him.
Penumbral players.
I agree to one aspect, my lord. As far as that is concerned, even the FIR, initially, if your lordship sees the FIR doesn't talk about rape at all. Where is that? Recording.
Lying last seen together and the recovery.
My lords, last seen together, there is also.
Any, you've sent the blood and the other
Yes, my lords.
fluids for DNA examination?
Yes, my lords. The
And also of the accused?
Yes, my lords. The
That
report.
whether any bodily fluids of the
Yes.
accused found on the
Yes,
body of the deceased?
Yes, my lords.
If your lordship.
There is one more additional.
These are the areas perhaps which.
My lord,
There is
there are
more
2 areas
focus
which are
to be
disturbing.
given, rather than, we understand your concern as a bereaved parent. But if you look at it from the perspective of investigation of the crime, it should be targeted more against the person against whom the allegation is one of murder and rape. And the clear investigational purposes.
Now, my lord, shall we look at it from that dimension?
Mr.
I will take you through that dimension as well.
Yes, that is.
My friend is saying that everything was done. Kindly see that the incident happens on 16th of March. Till 17th of March, 3:30 in the morning, the next day, around 18 hours of difference is there in even getting the first information report in place. And what does my friend, can I?
3:30 in the morning, Malaj. It's not.
3:30 in the morning is what I'm saying.
It's 3:30 in the morning.
Incident is happening at 6:30 in the evening. The aspect of the child having been brought dead is recorded at the hospital at 21:55 hours. Why is it that the FIR is coming into place at 3:30 in the morning, my lord? Look at the time period which has elapsed. And the FIR which is coming into place is an FIR which is coming into place only in relation to 302. There is no mention in the FIR of any of the offences of aggravated assault or in relation to rape, which is what I pointed out on the last date of hearing.
Sorry, I was just going through the status report.
Please, your lordship.
We better just examine the charge sheet.
Very well. Let them.
Because we would first like the victim's family's full satisfaction. The law will never be able to really, to our satisfaction, its moment will be fall short of unless the victim's family is satisfied. So, but at the same time, in our over anxiety, constituting SIT may unnecessarily may not further delay the proceeding. From that angle, you just examine.
My lord, I have only two concerns. One, the day the report is tried to be lodged by the father, he gets beaten up at the police station.
See,
a daily wager, a laborer, this is the manner in which they treat him. And now they are hounding him, saying this, that you have gone to the Supreme Court, please withdraw your petition. This is the manner in which he is being treated.
Did he receive this sort of a threat?
Yes. And he has been shifted from Uttar Pradesh to Delhi now.
The trauma and torture the family has undergone.
Please, Lord.
The trauma, the torture,
Yes.
the agony, and the kind of this pain.
The child and the hospitals don't treat the child, my lord. How can we in a country like ours even imagine a situation like this?
That's why we want that first of all, because they know everything that how the occurrence at the entire.
Why aren't they accepting the video recording, my lord? There's a video recording of the child where the child is seen to be alive. Why don't they take it on record?
They are referring to a video recording also. That's why we are just pointing out.
It's right here, my lord. I can give it to you. I can pass it across.
They are referring to some video recording. Is it the same thing or is it different
Of
thing?
my child, my lord. I am carrying my child.
Examine it. You are the best. With the assistance of the parents.
But my lord, they should first and foremost take that on record. They refuse to take that on record. They are going by the assumption that the child is dead at that point of time. That is the whole problem. And my friend says that no, everything is okay. Nothing is okay, according to me. It is highly disturbing, my lord.
Please try to understand what we are trying to do.
Yes, my lord.
Now they are coming out with a charge sheet which refer to some.
I will look into that, my lord. Tell them to give me a copy.
Recording, etc. They are referring to. Which video recording are they referring? Is it the same or different, or is it only a?
I will have an examination of that.
Only a kind of a just to.
An eyewash. Your lordship, tell them to give us a copy. I will look into it and I'll get back.
Just examine as a victim. You are entitled to a copy of charge sheet. You go through it.
Very well, my lord.
After that, if you feel that there are some gaps which have been deliberately left or because of their negligence it has been left, we would like an SIT to examine.
Very well, my lord.
But if suppose charge sheet has been filed, then there is a different kind of monitoring required. Then we will evolve that mechanism.
Very well, my lord. I'll assist you on that.
But
I will assist you on that.
That we are exonerating the hospitals or.
No, I'm not saying that. My only.
Those issues will be separately examined.
Very well.
We are not closing the issue.
Very well, my lord. My anguish is that a child is not getting treatment when the child is in this kind of a state. Maybe the child would have been alive today and we would have had better evidence. We have to look at it from that aspect too.
Now, where are the two hospitals?
Yes, I am representing respondent 4, my lords. And Joseph.
Lordship, I'm appearing for R3. I'm appearing for R3, your lordship.
R5?
R3, your lordship.
R3, that's it. Say in purported compliance of order dated 10th April 2026. A status report has been filed. Is it signed by someone?
The additional commissioner of police, Malaj. At page
Each page is.
21, Malaj.
Has been filed by some assistant, has been filed by an assistant commissioner of police. Police Commissioner Ghaziabad. The status report revealed that charge sheet has been filed. Before adverting to the various issues that we have briefly flagged in our order dated 10th April 26. We direct the police authorities to supply a copy of the charge sheet to the victim's family.
Along with that CCTV, my lord, which they are, the coverage that they are saying. So that I will be in a position to compare. Because my reading is that it is a CCTV of the location which they are trying to show.
That's right, Malaj. It's the CCTV.
Yes, so it is not that video recording which I am trying to give to them. Why aren't they taking that?
If there is any recording available with the Malaj's complainant, we can do additional.
He has been trying to give it to them from day one. They are refusing to accept it. This is what I am saying.
There is a CCTV footage.
Yes, my lord.
Which they are relying upon.
That CCTV footage is, my lord, at the time when they went to the site.
Which is the accused taking the victim, my lord?
The accused has gone and effected a recovery where they shoot the victim on the accused on his legs. It is of that period that they are trying to give. But this relates to the time when the child was recovered and the father had taken the child from there on a motorbike to the two hospitals.
Look into the documents and electronic material they supply to you, and then you make a response to us.
Very well.
So that.
Very well, my lord. All I am saying is let them give that CCTV record to me.
Yes, madam, you can also look into it and closing assess.
I agree.
Necessary further investigation can.
Malaj, that's what I'm respectfully submitting. If there is anything additional, we will carry out additional Malaj investigation.
Family. Post the matter on so date for further consideration. Meanwhile, the first number 3 and 4 hospitals are also directed to file their respective affidavits. In response to the allegations made against them. No further reason in this regard, no further time shall in this regard be granted. Post the matter for further consideration and so dates.
Malaj, would your lordships desire us to carry out further investigation on material that is supplied?
No, who will carry out that further investigation is the.
That is the issue.
So your lordships will hold our hands, Malaj.
That we have acknowledged them, their conduct.
I bow down, Malaj.
Under serious doubt.
I bow down.
We have serious doubt on their bona fides, the way they have acted. But today we don't want to comment because it may, unfortunately, if we commented anything and charge sheet is found all right, then it may prejudice the party. So therefore, we have to be very careful in observing anything.
So Malaj, we'll hold our hands now, Malaj. So Malaj, we'll hold our hands now. Whatever investigation we have done so far, that we have brought the certified copy of the file, Malaj. Otherwise, if your lordships desire the original file, it will have to come from the court, my lords. The court has given us the certified copy. Otherwise, court has taken cognizance.
No, we are not insisting on the original file. You can give us a certified copy. We have no issues.
Yes, to my colleagues, I'll give copy of the certified.
Give us a copy of the certified. That is good enough.
Title to these copies.
Yes, my lords, they could have taken it, my lords.
No, I happen to be the complainant. The entitlement is to the accused.
No, entitlement is to all. We've supplied copies for you also submitted in.
207 is in relation to the accused, not to the complainant.
We'll give you, sir.
Next Monday.
Next Monday, Manu? Because I don't think your lordship is free in the.
Sabarimala.
सब कुछ है नहीं, कुछ शांत रहे. Very well, Manu. So grateful.
My lords, your lordships would desire the presence of the commissioner. The ACP is here, my lords, the SHO is here.
We will not comment on today. They are reluctant in this matter from the very beginning. Reluctant in investigation, reluctant in FIR, reluctant in court assistance, because they are known for it. They wanted to become themselves. Unfortunately, we can't say something in court.
My lords, I'll leave it at that. I'll assist your lordships, my lords.
If they want to come, they let them come. If they don't want to come, let this enjoy their privileges. But if they invite some stricture, then we will not hesitate. I will pass it in open court. They should be aware of this thing.
I'm grateful, my lords.
Grateful, Lord.
Item 60.
Please,
Notice for Swansea.
sorry, notice, very great. Some returnable date.
Because I am accepting notice in item 60 minutes.
Very well.
Item 16:16.
60. May I request for a short date in 60 minutes?
We always give a date.
That's very well.
Please, Mills.
Item 16.
Yes, Mills.
Yes,
I'm sorry, Mills, I was not there for the first call, Mills. Mills, this is a serious issue, Mills. 2014, Mills, the states have been bifurcated, Mills.
How in interstate dispute, how the writ is maintainable?
No, Mills, because finally it was the Union of India to do it, Mills. And because both states are involved, Mills, they both are fighting, Mills. What has happened? There was a committee formed.
So therefore, who are
At
you?
page 69, Mills, the committee sat. Would my lords kindly see that? The committee finds that on 53 PS.
In a case of interstate dispute,
Yes, Mills.
who are you?
Because I am one of, this is an organization of the citizens,
Then every
Mills,
resident
who
of-
are the taxpayers, Mills, who are finally interested to
Every resident of Telangana, every resident of Andhra is also entitled to come. They will say, we are also citizens, we are also residents of that state.
Mills, he is a person of Andhra Pradesh, Mills. Mills, the same issue is pending before your lordships, Mills. The Andhra Pradesh has approached this court, Mills. May I just pass on where notices are issued, Mills? And the same issue is taken up, Mills.
No question. Don't take the question. If you entertain this kind of reputation, there is no end. You want to defeat the constitution scheme itself.
No, Mills, we are not, Mills. We want that it should be implemented, Mills. And therefore, would Mills, may I just indicate annexure P4, Mills, for a moment? Mills,
We are on the locus.
yes, Mills.
Who are you?
Mills,
To raise an interstate dispute.
yes, Mills. Mills, this organization is by the persons, Mills, who are the taxpayers, Mills. We are finally saying, Mills, because these are the assets of the state, Mills.
The issues sought to be raised in this reputation emanate from provisions of the Andhra Pradesh Reorganization Act 2014. Those disputes are essentially between Union of India, State of Andhra Pradesh and State of Telangana. Essentially revolve around the provisions of Swansea Act. The issues essentially being interstate dispute, the petitioner has no locus standi to raise this issue. The petition is accordingly dismissed as being not maintained. only on the maintainability.
Homeland.
Sorry. Item 51. Where is Mr. Parmeshwar?
He's just outside me.
वो कहाँ गया हमारा?
Sorry, let's.
Let's. I mean, your lordships have directed us to classify this matter. There were about 800 applications, but there are not 800 matters because every.
Now, this is your brief note or another petition before us?
Plus, I'm saying 800 matters, because unlike the MC Mehta matters, these are matters across India.
How to dispose of this matter?
Plus, there are three suggestions, Milats. There are 800 matters, 800 IAs, but 800 IAs do not travel into 800 causes of action because each matter comes with an IA for intervention, implement, exemption, etc., etc. So we have now broadly classified into 7 or 8 categories. There is an entire set of miscellaneous categories, Milats, because of the last 30 years of matters, Milats. These are IAs pertaining to one-off state matters. There's an IA, say, from West Bengal, one IA from Nagaland. They are not susceptible to classification strictly within a group, but broader group.
So, if going by your index, some of the IAs will be relating to protected areas.
Protected area.
What do you mean by protected areas?
Because these are protected areas defined under the Wildlife Conservation Act 1972.
So therefore, protected areas under the Wildlife
Conservation. That's right.
Right?
That's right.
Second, determination of eco-sensitive zone and activities permissible.
That's right.
Right? Third, issue with respect to violation of forest conservation.
But this, may I just make a...
It will be very, very exhaustive.
Because this, unfortunately, what has not been brought to the notice of the court, this is an appealable order under the NGT Act now. An order granting or rejecting forest clearance is an appealable order under the National Green Tribunals Act. The Wildlife Conservation Act is not present in the schedule to the NGT Act. Therefore, the first two categories, most of them are also matters which involve more than one state. The lordships knows, most of the protected areas.
4 will be overlapping.
Again, 3, 4 is specific matters which your lordships have passed orders and said no other court shall pass orders in respect of these areas because your lordships have given categorical directions that mining should not take place in these areas. So item 1 and 2, it can't go to NGT because neither protected areas nor eco-sensitive zones are technically notified under the National Green Tribunals Act. Item 3, Milords, is clearly any order passed under section 2, and your lordships have also clarified, Milords, that the High Court's jurisdiction is not taken away merely because the NGT tribunal is there. So item number 3, all matters pertaining there, Milords, actually there is an alternative forum that is available. 5, 6 and 7, Milords, item 6 is the largest bucket among the 800 IAS, Milords. It's issues with respect to Aravalli Hills and Ranges. Milords, this, my submission was, it must actually
go with that.
That's one motor which your lordships have initiated. Plus item number 7, Campa.
Why don't we do one thing? Serial number 5, notification, identification, mapping, encroachment and forest area. Something will be referable to number 2, other will be referable to 3, or some left out might be referable to 4. And in any case, There may be a notification pertaining to mining, the other may be